Hi, my name is Valentine. Welcome to my legal toolkit. Firstly, in my toolkit, we'll look at sources of law, the Constitution, common law, equity, statutes, interpretation of statutes. So this just gives you high-level description of what these are, and the purpose of this is just to highlight and remind these sources of law. And then in the toolkit we go to, this is the main menu. It is divided into 7 elements. The first element is talking about identifying the problem and issue, and this we shall cover in more detail when we look at the IRAC method. Section 2 then deals with which area of law does your issue or problem apply. Section 3 talks about which court is applicable in this case. Section 4, we then look at the tools to be used to solve the case. Section 5 looks at the strategy to be applied. Section 6 then looks at applicable theories. And Section 7, we look at the client-lawyer relationship. So if we click on Section 2, which takes us to which area of law is your case. So if you look at, then divides this into 4 distinct areas: criminal law, civil, public law, international law. And under criminal law, it then further differentiates the different types of laws. And here I've given an example of traffic law, public order, property, people. If you go to civil law, it looks at contract law, employment law, family law, torts. Public law, same thing, it breaks down into different sections: administrative law, migration, human rights. And then you look at international law, which looks at treaties, bilateral agreements, multilateral agreements. And then we have a button here, which then, if you click on it, gives you the different courts applicable and the different jurisdictions for these courts. So we have tribunals, lower courts, intermediate courts, superior courts, and also breaks down to different states and territories. If we go next, we then look at, we've broken down how we're going to take this approach into 3 areas: tools, strategy, and theory. If we click on tools, this is further broken down into 5 sections: doctrine of precedence, ratio decidendi, obiter dictum, purpose rule, research. So if we click on doctrine of, just go back, the doctrine of precedence, this is further details talking about what doctrine of precedence is and the fundamental constraints of judicial decision making in Australia. Also gives you a triangle here, a hierarchy, lowest courts, intermediate courts, and also talks about the types of precedents: original, declaratory, binding, and persuasive. We go back to the tools. We look at ratio decidendi, and this is the reason why, or the basis of a judgment in a case. And here we also outlines how do you find the ratio decidendi in a case. And we also have a chart here which just shows you the legal issues, the decision, and the order. And we also look at the dissenting opinion in a judgment, and this is the opinion of the judges with an opposing view or a dissenting view. And as we know, the dissenting opinions do not affect the judgment. We go back to the tools, and then we look at the purpose rule. So this is looking at the purposive approach. This is a modern day version of the mischief rule, and it's an approach to statutory and constitutional interpretation under which common law courts interpret an enactment. If we click back, we then look at research. So this is giving us the sources of research data that we can look at. So when we're looking at federal or Commonwealth law, we can look at the Federal Register of Legislation, the Parliament of Australia. You can go on their website. All the current and previous repealed or amended legislation can be found there. We also look at state or territory parliaments. They have individual websites where we can go and look at the statutes, the second reading statements, any bills in Parliament. You can also see those. And then we also look at authorized websites or databases such as Westlaw, LexisNexis, Halsbury's. We also look at law reports and journals, authorized reports such as Australian law reports. We also look at, there's some unauthorized databases such as Ostley, Jade Barnett, and then we look at case law. There's also regulatory bodies, people like ASIC. They also bring out regulations and guidelines, local governments or councils. If we go back to our tools, we then go back to the main menu. So we've looked at the tools. We can then look on strategy. We've broken this down into inductive reasoning, analogies, IRAC, factor law distinction. So if we click here, it then takes us to a bit more detail. Analogical reasoning. This analogical reasoning is central to legal thinking. This is commonly associated with precedential law. We also look at golden rule of logic, inductive reasoning, and law versus facts. We spoke about that. When you're looking at case, identify what is the facts and what is the law or the mischief in the case. We go back to our main menu. We'll just go back to strategy, and we'll look at IRAC. So IRAC stands for Issue, Rule, Application or Analysis, Conclusion, and we've further defined what each one talks about. And this tool is supposed to help myself or somebody else using it just to understand how to use the IRAC method. We then go back to theories, applicable theories. So this area is broken down into equality and rights theory and what is the rule of law. So if we go into equality and rights theory, I've further broken down this into sort of 3 areas, but this actually is a broad area, and being constrained by space and time, I've just managed to highlight these few items about upholding human rights, rights of freedom, rights to assemble, rights to a free trial, rights to be informed promptly in circumstances where you're being accused. Also, we talk about being innocent until proven guilty. Also, equality in front of the law, regardless of race, gender, disability, sexual orientation, or age. If we go back to our main menu, we'll go back and we'll look at the client relationship. We'll look at lawyer's duty to a client. So duty of care, ensuring there's no conflicts of interest, confidentiality between a lawyer and clients. We'll talk about excellence, providing the best work, best to your knowledge and capability. Negotiation and transaction skills. This is crucial when you're negotiating on behalf of your client. We then look at duty to the law. Lawyers must at all times act within the law and uphold the law when engaging their occupation. We then look at client communication. So keep the client up to date on proceedings, communicate clearly your fees and estimated costs. Attorney-client privilege. You cannot disclose information that